So one of my fondest memories from NALSAR days is the both of us participating in the Tata Institute of Social Science paper presentation competition in Mumbai,
Yes.
where I think our paper eventually won the competition. We also received a standing ovation. So it has stayed with me. Besides this, you were also very active in organizing events in NALSAR. You know, I remember you were very passionate about the damson displacement issue. You had worked with Meeda Patkarji and you wanted to organize a forum in law school calling all the stakeholders. So you've come a full circle, right, as a student organizing events in NALSAR and then going back to NALSAR in March 2025 as a partner at KSK to organize the commercial moot court law competition.
So I think it was very important for me to not get influenced by left or right as a student or even as a lawyer. So this is going to be a skill which will be a lifelong skill where you are not going to be biased in your thinking. And this thinking of not being biased towards left and not being biased towards right or not even thinking you're center, you have to absorb knowledge and information in the most neutral manner. And that was the whole purpose of colloquium.
Have there been instances where you have represented a smaller client against bigger corporate or a bigger client with unlimited resources and then because of your strategy, you won the case for your client? Have there been such cases?
Very important to be confident and very important to feel for what your client is asking you to look into. You should not dismiss a client's input as they don't know law. You don't know facts. You have to absorb them. And second thing is fearlessness. Whether you're standing in front of against a chief minister of a country, of a state, or whether you're standing against one of the very, very intriguing businessmen who has large businesses, you must stand on your feet and tell something which you really feel is right, which is really right as per law. Then feel like, oh my God, I'm going to lose this case. He's so big, I can't win it. They're going to deploy senior counsels. I will lose. I have argued matters against senior counsels also very systematically, logically. So not to get intimidated because of the whole situation that's created around you. So going back to fearlessness, going back to neutrality, and going back to honesty and going back to hard work.
Right.
Honesty is also because many a times, people think that lawyers are getting compromised.
Right.
But you are your own talisman. You can look to Gandhiji, you can look to Ambedkar, you can look to Tagore, but you are your own talisman.
So I think self-confidence and fearlessness takes you a long way. You have learned Kannada. In fact, I wanted to bring that up, right? I think I'm very proud of you for learning Kannada so well. I know a lot of people who are in Bangalore for more than a decade or so and they don't still know a word of Kannada, right? So I always show your example.
I started watching a lot of 1970s and 80s Kannada movies for good language. And that's how I picked up Kannada. It connected me to people because Bangalore is my home. And wherever I make my home, I have to speak their language. And this has also been my philosophy in court that if I am going to argue, even if I carry 10 judgments, if I cannot explain to a judge what I'm trying to convey, I will never get any order. And the language Kannada has become actually a blessing for me because I can communicate things to a judge more easily, blending it with other language.
Right.
Same for clients. Clients, they may be really good English speakers, but when I tune to Kannada, they are giving me more information and they are so happy to give that information. The connection. Lawyers is all about connecting.
You are a Bengali who loves your fish curry and rice and you're married to Manu Kulkarni who is a Kannadiga and is a vegetarian. So that's a very interesting cultural mix at home. What has been that journey like for you?
What matters is affection and respect for each other, which we always had.
If you weren't a lawyer, who would you be?
I would say an honest politician.
Hi Sunana, welcome.
Hi Kirti.
Hi. So I have known you since the college days, since the NALSA days. But for someone who doesn't know you and is listening to you for the first time, how would you introduce yourself?
I would introduce myself to be somebody with a voice, whether I implement for my clients or for any cause, and I'm an eternal optimist.
All right. So it all started at NALSAR, right? I got to know you at NALSAR. So let's begin there. What influenced your decision to study law at NALSAR?
Thank you, Kirti. I think it is a question that also comes to my mind quite often. And I think from childhood, I had a problem-solving attitude. My father was into politics, and he tried to solve a lot of problems of public at large. So from my desire to solve problems and to come in and out of crisis, I chose law because law has transformational abilities to bring in changes in the life of individuals who go to court and to bring in decisions on subject matters which impact lives of people. And that's the reason I chose law. It has terrific capacity not only within a country, but to transform lives of people who are living across the world.
Right. I couldn't agree more with the fact that, law is transformative. The justice delivery system is transformative. I still remember the day we all walked in and Professor KDR asked this question to most of us, I mean, all of us there, right? He asked, why did you choose to study law? So it's still so fresh in my memory.
Yes.
All right, so moving to the next question. We faced the camaraderie and the pressures of law school together. You even met your husband, Manu Kulkarni, who's also my friend at NALSAR. So what are some of those memories that have stayed with you?
There are quite a bit of memories, but to just name a few, I think we would do a lot of extracurricular activities, and we were actually fighting a popular perception that Moot Court is one of the only extracurricular activities that we can do.
Right.
So I think we did a lot of conferences, a lot of paper presentation, a lot of oration, and a lot of brainstorming in what we are doing in our projects. So projects were more important to us than really passing the tests.
Correct.
And I really thank my professors to kind of urge us to think. I think the whole environment we were in, I think our peers, the questions that were asked in the classes, everybody was thinking. And even a professor urged us to think and, kind of put new benchmarks to what we have already thought about life, what we have thought about our day-to-day usual sense of things.
Right.
From religion, from caste, to being a woman, to studies, to the way we study. I think everything was put to question.
So one of my fondest memories from NALSAR days is the both of us participating in the Tata Institute of Social Science paper presentation competition in Mumbai.
Yes.
Where I think our paper eventually won the competition. We also received a standing ovation. So it has stayed with me. Besides this, you were also very active in organizing events in NALSAR. I remember you were very passionate about the dams and displacement issue. You had worked with Meera Patkarji, and you wanted to organize a forum in law school, calling all the stakeholders, state representatives, activists, academicians, to have a very balanced and healthy discussion on the issue of dams and displacement. So you've come a full circle, right, as a student organizing events in NALSAR, and then going back to NALSAR in March 2025 as a partner at KSK to organize the commercial moot court law competition. So my question to you, Sunanaya, is how important do you think these events are, these paper presentation competitions, moot court competitions, in helping the students develop real-life skills to face the world of law, or even to think deeply and research deeply on issues?
I think, thank you, Kirti, for drawing the dots from, I think, 2004 to 2024, and then 2025. So 20 years. I did the first colloquium for law and development in college, wherein we brought in multiple stakeholders from government, from social workers, from policy thinkers, and IAS officers. So I think it was very important for me to not get influenced by left or right as a student or even as a lawyer. So this is going to be a skill which will be a lifelong skill where you are not going to be biased in your thinking. And this thinking of not being biased towards left and not being biased towards right, or not even thinking you're center, you have to absorb knowledge and information in the most neutral manner. And that was the whole purpose of colloquium, and I think that is the whole purpose of learning in law school. Not because we have a superimposed notion of black and white, but because as lawyers we have to be neutral when we argue a matter for a client, and as judges you have to be neutral when you decide a matter. So the principle of not being biased have to be inculcated within you very early in your life. And what is a better place than a law school? In terms of activities, moot court brings out the best of your adversarial skills. But there are plenty of other things that you can do. You can do parliamentary style oration. You can do paper presentations where you're trying to bring in a thesis and trying to prove it, showing your spirit of inquiry, which I think really helps in final arguments in matters. And you can do a host of other things, even performing arts for that matter, because that makes your brain agile. It is not only about moots and doing 5 to 7 internships with law firms beginning from first year,
Right.
but it's about the diversity in which you're going to garner your skills during your 5 years life to become a more rounded lawyer eventually.
In fact, I had a follow-up question, right? You've been practicing in the courts for the last almost 2 decades now. And there was this mindset in law schools that everything somehow boils down to being a good mooter. And there was also this perception that if you're a great mooter, that necessarily means you're going to be a great lawyer in the future. So how much of that is true, going by your own experience?
It is true, but I would say 50%, not 100%. Being a good mooter definitely brings out your adversarial, argumentative style, your understanding the criticality of a finer legal argument. But a non-mooter can also go ahead and become a good lawyer because they are equipped with a sense of questioning, doing adequate inquiry, preparing a brief, and then arguing your matter.
Right.
And that skill, if you can pick up by a host of other things that you can do in college, including writing your projects well. Not to go to any kind of material and just copy it. Try to process it and just do it. I think that is a very effective way of becoming a very good counsel or a solicitor. Because both actions are very important in the whole advocacy situation in India. And coming back to your question, Kirti, on the first NALSAR, KSK LAW commercial moot court competition, I think the same thing. There was so much of energy. We could have judges from different experiences. We had alums of NALSAR who were in trial judiciary who had come to judge. We had alums of NALSAR who were in high court judiciary who had come to judge. And we had senior counsels from NALSAR who had come to judge. And we had general counsels from NALSAR who had come to judge. So I was just like, this was a boiling point or a melting point for a lot of people who have stepped out of NALSAR after graduation and have actually done something transformational in the spaces they are in and a very, very early age of their life.
Right. So you seem to have had a great time organizing the moot court competition, and probably with a lot of help from the alumni who came back to judge the competition. So
Yes.
that must have been wonderful. So let's move to where you all started, right, your career. After graduating from NALSA, you joined one of the biggest corporates in India, Reliance. So how was that experience?
It was very good. I would say as a learner, I got to work with a very good team of lawyers who were from National Law School. And I could learn a lot of documents line to line, a review line to line, iteration and reiteration of a line to line, and perfection. And not to say that templatize everything. And because we were looking forward for conceptual clarity behind a document, we would spend maybe a couple of days more, but we had more satisfaction in doing it. And the document would go well through the business teams and thereafter the negotiation that would happen. And there was plenty of M&A and acquisitions, foreign, globally acquiring companies abroad was happening during that time. I think it was a very enriching experience because in Reliance it's a very large organization. And there is a possibility of you getting lost. But that didn't happen because of our seniors who were guiding our team then. And also, I did make an effort to purchase a lot of books to understand the conceptual clarity behind clauses. Because if your concepts on clauses are not very clear, then you are going to do it rather semi-mechanically, if not absolutely mechanically. So I think in that sense, Reliance was really good because they were into multiple sectors and we could read up on laws of various sectors and deepen our knowledge within the sectors to do documents. And we were always doing documents from the scratch. There was no template. Of course, there was template, but we efforted to do documents like a foundational concept and then build on it, which is something which I really learned in Reliance.
So after Reliance, you took a shift and you moved towards the world of litigation. What inspired you to go and plunge into the world of litigation? When did you realize that disputes and litigation were a true calling?
Maybe around 2011, where I thought I should I should do something more about developing and enhancing my legal acumen. Because if we are reviewing a clause and then we do not know what is the fate the clause is going to suffer
In
eventually.
practicality, yes.
Secondly, sometimes as corporate lawyers, we are fighting on 10 things. And we are willing to give only 2 out. And we are going to fight for these 8 things. But if you have a good legal acumen, you can really know what are the 3 things you should hold on to
Right.
and let go of the remaining.
Right.
And not to keep on prolonging the whole negotiation for something which will actually not see any meaning when it's fought in court. I wanted to be a rounded lawyer. As I told you in an analogy, imaginative analogy, I wanted to carry my client's brief in a briefcase, to be very, very specific, and open up the briefcase before any forum I'm appearing, whether it's the courts, whether it's competent authorities, whether it's the tribunals, whether it's the politicians we are appealing to, whoever. I wanted to become a lawyer with the skill sets to argue something which would make sense, to tell or weigh every word of what you're telling, which will make sense to the other side. Whether you're wearing the hat of a arguing lawyer, or whether you're wearing the hat of a mediation situation, or you're wearing the hat of just pure conversation to figure out what you can do in your settlement talk. You need to have that kind of acumen to say what you're doing is actually not diminishing your right of a client. It is not eclipsing the right of your client, but it is the ideal way out. To develop the legal sense, I embarked on the journey of going to court.
Right. So how was the transition like, Sunana? You went from a very structured corporate world to the uncertainty of courtrooms with its own challenges and delays. How was the whole transition like?
It was a very good sense of shock. But I think I absorbed it well because you are used to working around routine and a certain kind of pattern, which I did for 4 years of my life as a corporate lawyer, which I had to break when I went to court. And there was actually no time. There were clients coming at 9 p.m. in the night and expecting you to do something by next day at 10 a.m. So there's no time you are going to work in. And even when you're working with a senior's office, you cannot say, I'm going out of office at 8 o'clock. You have to be engaged. It is something more like your engagement with art or music. You have to be engaged with the brief you're working with. So in that sense, I think there was no routine. There was no pattern. You can expect anything in that particular week to happen, and you have to absorb it. The second thing is, I think when I went to court, there was a lot of passive and active learning. You're seeing people argue, you're arguing yourself, your senior is arguing, judges are telling. It's just an ocean of knowledge, provided you are willing to grasp it.
Right.
And you cannot really swim there. You can only float.
What do you mean?
I mean, see, you're a junior lawyer and there's a lot of things happening there. You can absorb it and learn. There's a lot of passive learning happening out there. So I think in that sense, that was really, really enthralling. However, the last aspect I would tell everybody who is taking this call of going to court is to be ready for challenges. You are not sure when you're eating, when your cup of coffee comes. You're absolutely uncertain when you're going to get your first fee or continue getting your fees. And you're definitely not sure whether you're going to get an order or not.
In fact, I have a follow-up question there, right? So if there's a student or a young advocate, lawyer, who's confused or rather undecided between the world of the corporate world or the litigation world, what would you advise them?
I would say rephrase the question. Because corporate world versus litigation world are not really versus. Because if you are good in surgery...
By corporate world, I meant somebody who is sort of deciding between in-house legal counsel role versus going to the courtrooms, practicing with senior advocates. How would you help them choose? What would you advise them?
I would say go to courts first. I would say that. There is no harm if you go to companies in the first shot because you will have other parameters why you would need a job, which is decently paying. But do visit, go back to court and spend at least good 3 years in court, 4 years in court to figure out what is happening there.
Right.
Because it's all about we being doctors or we being lawyers and we need to know how a surgery happens. And then you will always be giving good advice to people as general physician or any other stream of medicine. But you need to go to court and figure out what is really happening there. Because that is a predominant scope of work. You can always go back to in-house, but you can always jump back to litigation. There's nothing stopping that. But do go to court in your lifetime.
So that brings me to the next question, right? You've been practicing for the last decade or more, and what is your perspective on the current state of the Indian court systems, right? There are inordinate delays, and people try to stay away from the court system as much as possible. And most people say that the justice delivery system is broken because justice delayed is justice denied. So, in the last 10, 15 years, have you seen any tangible improvements in the Indian court system?
I would say the volume of commercial matters have increased, which eventually led to the creation of the commercial courts in India.
Okay.
I must applaud the last 8 years of government effort to amend several acts. But going to evolution of court system and technology, I think technology has really helped our life. A lot of hearings are online now. We can actually check online case status. We can apply. We can look for a certified copy status. We can update our case dates. A client can online enter a hearing and see what's happening. There is a lot more transparency. Earlier, I would say that you are really doing things mechanically and manually, but right now, we can't do it. So we are almost saving 25% of our time because a lot of it is digital right now, and which is amazing.
Right.
Second thing is also, Kirti, about our land records also being digitized now, which has really helped because in a place like Bangalore or Hyderabad, which is an evolving city, land litigation will always be a part of your life, even if you're a corporate lawyer or a corporate litigation lawyer. And these records have become digital since 2000, which is really, really good. So I would say that digitization has really helped in our courts. And the courts are proactively telling things that we have to move things fast. They are not giving you long dates. They're willing to hear your matter. So I would say it's a rather good situation right now. And there is definitely very effective steps of progress here.
That's good to know, Sunana. So if you were to recommend certain systemic changes to the current court system to make it more efficient and accessible, what would they be?
I think I would look at it from a completely out-of-the-box situation where I am telling that we can consider having a night court, and we can split court timings into two. We can have court timings between 8:30 in the morning to 4:30 in the evening or 3:30 in the evening, and have another round of court sitting from 4:30 till evening, which actually not only splits matters, and judges who are sitting in the daytime can actually leave early to rest in the evening, and judges who are coming in the evening can rest over the course of next day.
Yeah, basically different shifts.
Shifts. And if we have so much of pendency of matters, we have to think about it.
Right.
If all the technology workers or all the other workers, people do work in shifts.
It's a very interesting point you make, Sunana. I think that's possibly something. Have there been any discussions regarding this anywhere?
I don't think so.
No, not yet? Okay.
Yes.
Okay.
But I think it's going to really help in bringing down work. Other situations also, sometimes clients are coming to you around 12 o'clock or 1 o'clock with a problem, and you can escalate that in the evening. And that is really, really good.
Yeah.
If you have morning and evening courts working.
Right.
Of course, not for everything, but for some segments, we can definitely consider morning and evening courts and bifurcating judiciary, and advocates can also decide which of the courts they're going to go more often.
And which matters can be taken, on an emergency basis or whatever, right?
So I'm telling you that if we can
have evening
have
courts.
this, instead of overstraining a particular judge to work till 6:30 in the evening, who is sitting at 10:30 in the morning, they cannot possibly work till 6:30 in the evening.
Right.
So why don't we break it up and maybe look at it as a completely different, with fresh pair of eyes. So that is one thing that I would strongly recommend now.
I think those are some very interesting points you make, Sunana. So, after you've been practicing and you worked with certain senior advocates, and then you went on to start your own law firm, Common Law Chambers. What inspired you to do that?
The same thing, I think a couple of things I would say, Kirti, is I think the same call of problem solving and transformational effect of law, these two blended together. I would say that I started a firm because I had enough number of briefs. If I didn't have enough number of briefs, I cannot start a firm. That is to begin with.
Right.
But once I had the number of briefs, my day-to-day motivation was to see how best I can solve them quickly. Because as if I delay it, if I sit on it, nothing is going to happen. And this was the predominant thing that I thought that I can fight through my internal mechanism and through my team with whom I can develop this value that we can as lawyers fight the tardy process of law and get outcomes for clients amidst a slower judiciary. And I started in a very pre-technology era where we would enter court dates and everything in a diary in a manual manner. But now I'm so glad everything is digital because we can save a lot of time.
I think that's definitely a positive transformation that's happened with the courts, right?
Yes.
Things are much more accessible and faster, efficient now. That's great. So Sunayana, when you started CLC, right, you were not just a lawyer anymore. You're wearing your entrepreneurial hat and you are managing a firm, which means that it comes with its own set of challenges, right? You're hiring the team, building the team, you're managing the finances, you're also building credibility and finding clients. So what were these early challenges like while building CLC?
The early challenges for me was one, as a women lawyer, where will your office be? A fine balance between your own profit and efficiency. Because if a client is paying you a couple of lakhs, and if you think of just not engaging the right people, not doing the right things, saving on all corners and just taking out the maximum amount of money from there, you will not really be efficient. And your client will not get what they really want. So I compromise profit for efficiency. Because efficiency is a much more sustainable battle to play. Because you're going to win it, because if you're efficient, your clients are going to come back as a recurring client. And they're going to recommend more counsels to come to you. The other challenge I faced, of course, was hiring. Because I was hiring many people who are older than me. And I started my firm in my late 20s. And a lot of people were proficient in Kannada, as well as I was not. And a lot of people were older than me. And I had to really give them guidance. Which means I myself had to spend a lot more hours studying and internally being clear on my own concepts to give them guidance. The third aspect is clients. When a client sees a younger lawyer, the trust doesn't just immediately rise up.
Correct.
Until unless your solutions appeal to them. And they will always go and ask people that what she's telling, is it true? Can she do it? So they will always do a backward check.
Right.
And being a young lawyer and getting the kind of confidence from clients was not easy. But I did it through one or two things I learned from law school to give answers only after reading them and not some casual responses. Go prepared for meetings. Understand what your client wants. If you do not have an answer immediately, tell them that I'm going to take 24 hours more to read up and to do my internal thoughts and get back to you. You don't really need to tell them that you're reading up, but you're going to do your own homework. But give a very, very effective answer. And that has been one reason why clients, I feel, I could grow my practice from a brief size of 25 briefs to about 400 briefs over the course of 9 years.
That's fantastic. So Sunana, you touched upon that briefly while you were responding now. Your hiring philosophy, right? So when you were building your team, I think a lot of young folks listening to this might be interested in what are the qualities you look for when you're hiring, whether interns or even associates for your team?
I would say to H or to H.
What is
whatever.
that?
But I would say that it is honesty and hard work.
Huh.
As a junior lawyer, if you're dishonest, if you're manipulative, if you're smart, over smart,
Too smart, you mean?
then it becomes a very big challenge for you to handle. Second thing is hard work. One is work seen to be done and work actually done. And hard work is an outcome of the latter. People who are really hardworking need not show that they are working. But their work will reflect in the drafts they make, in the opinions they form, and the assistance they give you in court. And I have been very lucky to train a bunch of people who are very, very introspective and hardworking. And I would have possibly trained 3 rounds of lawyers in my last decade who who has currently even joined lower judiciary and very successfully joined other in-house companies, and reflecting what they have learned through my office in their day-to-day work. But I would still say honesty and hard work are the two, kind of say noble qualities I would look forward, because law indeed is a noble profession.
So it's good to know that you've been mentoring, folks that you've hired for your teams, and they've been doing well now. And also that honesty and hard work are the driving qualities that you look for in students. Everything else can be picked up or learned, but these two, I think, are very integral, right?
Yes.
I agree with you. So Sunayana, what led you to merge CLC with KSK? You're today a partner at KSK. What prompted this decision?
I think midlife introspection.
Okay.
I think I was doing pretty much a very diverse portfolio of clients. I was doing work for them in trial court and high court in Karnataka. But I did feel that I'm not getting the matters which I was 1,000 crores. Because I'm a law chamber who is less than 10 lawyers with some 3-4 paralegals. And companies don't want to come to a small law chamber.
Right.
They want to go for larger setups, a larger organization.
Right.
So I thought internally that why don't I bring in my internal milestones and changes I wanted to make within the larger milestones of KSK, because KSK gave me the umbrella and the platform both. I could accelerate my practice to say that earlier I was doing matters between 10 crores to 20 crores, and now I do matters between 100 crores and 1,000 crores. And KSK, I think, has been a very innovative law firm with very innovative outlook and rapidly growing. And I could see my pace of, my vision of growth matching with KSK's. And that's how I got into their bus. And I am in it.
All right. So it seems like you're really enjoying your role as a partner at KSK.
That's true.
So Sunayana, going back to as a practicing lawyer, right, founding CLC, what is the right time for a lawyer to start their own practice?
There are no hard and fast rules. There are very good counsels who I don't want to take name, who have only worked with senior counsels for only 2.5, 3 years. But, and then they have now gone on to become senior counsels. But I would say that 3 years to 4 years, because that's a good time for you to see a full cycle of a matter, right from the filing to evidence to the final arguments and the argument, and then whether you should go on an appeal or not. Right? So 3 to 4 years, I would say, good to be with a senior, until and unless you are not connecting to your senior's practice or way of work.
Right.
Then you can switch, but be there for 4 years, and then move on to, then you will get definitely clarity of what you want to do.
Sunayana, for someone outside the legal profession, what does a disputes litigation lawyer do on a day-to-day basis? What is something that you would recommend for being a very effective disputes lawyer?
Spend some time with yourself alone on a daily basis. You may sing a song during that time, or you may meditate during that time, or you may recite a poetry during that time, but spend about half an hour with yourself, because a disputes lawyer, when they walk out of their house at 9 a.m. in the morning, you never know what's going to happen in the entire day. So it's very important to have a moment of calm either in the morning or in the evening, and to introspect about what happened. Because that will really help you to rewind and bring back the positive energies around you back to your system. Because what you will go through over the course of the whole day is a lot of energy which may be negative, which may be cynical, critical, but you have to be positive. Because you have to convince the court, your client must get the result, so you have to demonstrate, as I told you, optimism. Right. And that is one quality I would say. Second thing, Kirti, just to push back on what you asked me initially about NALSAR and the qualities they should also look at law school, any law college student, is not to view law as a degree which is professional. Law as a degree is a degree of art and profession. So you cannot really look at it like an MBA. You cannot look at it as if you're going to get a package after the graduation. It's going to be this amount of money, and then you're going to jump to this kind of salary. I would say that look at it from the perspective that do you really get to learn that kind of skill in the first 4-5 years of your life. You are in a Gurukul.
But Sunayana, how would you respond to people, maybe they've taken loans, they are economically in a tough situation and they would want to start earning. And I think some of the starting salaries in litigation is really low. I think it sort of makes a lot of people think twice before entering into the world of litigation, right? At least I know a lot of students when we were graduating out of NALSAR or even otherwise, right? A lot of them choose the corporate path primarily because the starting salaries in litigation for at least the first 4, 5, 6 years is very low. What would you have to say about that?
I would say that if I am doing history or if I am doing literature, I'm not expecting a lot of money. Then why am I expecting that kind of money when I'm doing law?
Because law is not just literature and, law has transformative power. It's a services that you're providing somebody, right? And you also have the ability to just deliver justice there. As corporate lawyers, we are constantly sort of risk managing for the company, right, on behalf of the company. And as somebody who's a practicing lawyer, you're trying to get the best deal for your client, ensure justice is delivered. So to that extent, I wouldn't equate, say, an English graduate with a law graduate.
True, very true. I think I get your question, Kirti. I, in common law chambers, would try to give my best shot in paying people because that's the space that I can control. In terms of giving health insurance, in terms of arranging for lunch, in terms of giving them a decent pay package every month so that they go home and can sleep and rest in peace. And I would recommend that for any other litigation seniors who are here listening today to do that for their juniors because that is going to be a very, very big booster. But I think as law school, if we can keep our tuition fees also not very high, that kind of eases the pressure from the shoulder of a student. Because if you're going to spend 10 lakhs in studying law, then there's pressure to kind of pay back your education loans, in kind of being justifiable to your parents, etc. I think first 4 years of your life, even if you don't save enough, but if you're getting the right skills, you should aim at that. And after you get the right skills, your skills will always be valuable to a company who is hiring you.
But what would you say? I mean, I'm just playing the devil's advocate, right? Suddenly, the law school folks would say, hey, we're also investing a lot on the infrastructure. We're trying to give you global education. We are subscribing to a lot of these legal databases, and also the pay packages for the professors themselves, right? There's also another point of view where professors say, hey, the law professors are really not paid well. There's also that side of the argument. So where do you draw the line here?
I would draw the line in favor of practice and in favor of advocates because to my knowledge, if we are really thinking of subsidizing fees, that is more critical because we want future lawyers to really know the law. We cannot have lawyers who have superficial understanding of law. And to know really the law, you have to go to court. To know really the law, you have to at least witness courts for 3 years of your life.
So right, so you are advocating that students should be more geared towards practicing more
At
than
least
the first few years.
or mid few years. If you have initial commitment, you can join a big law firm, you can join a big in-house role, but step out of that zone and do practice for some time because it is going to be a very, very life-changing experience for you.
So, and you're saying that keeping the fee very high would sort of tilt the students,
in favor of corporate
practice, right? I think this is something that maybe next time when you're in NALSAR, you should probably have a discussion with Professor KDR on this. You can probably hear his perspective on this as well, right?
Yes.
Yeah. So, Sunana, you have worked in various forums, right? Trial courts, high court, Supreme Court also maybe to an extent, also arbitration. Where has been your learning curve the maximum, and which forum is the most challenging of all these?
I will go to a popular one-liner that our law school's teachers would tell, especially teachers who have practiced and then gone to teach law. Spend 10 years of your life in trial court and then go to high court, and to which we found no merit when we were in college. But as I practice law, I think trial court practice and trial court understanding is also very, very critical, and your mind is being challenged, if not in the first round, in the second round. When you're arguing a matter, when you're arguing an interlocutory application, when you're leading an evidence, when you're asking for an expert witness to be appointed, cross-examining the expert witness, and the arguments. So I think trial court are the first court that you go to when a client faces any problem. So that is the first court. We don't go to High Court. High Court is an appellate court.
Right.
Until unless you have a constitutional right being violated, you go to High Court. So that is my thing, that trial courts, whether earlier there was only civil courts, now we have commercial courts.
Okay. Since
We have
when has
DRT.
this development happened?
2020 onwards.
Okay.
We have functional commercial courts in India. We have debt recovery tribunal. We have NCLT. So wherever you go in the tribunals or in civil court or even the Karnataka appellate tribunal, and synonymous tribunals across different states, you would find that you are going to learn a lot more in trial court. And then when you go to High Court, parallelly, you will connect the dots.
Right.
But if you have not gone to trial court, you will not be able to connect the dots, and you will only think that ornamental arguments, citing cases after cases, are the only way to argue a matter. There are two pillars on which you are going to build your client's case. One is a case on merits, and the other is on law. High Court, you will see a lot of action on law. On merits of the matter, it is a trial court where you're going to go back to, for which you need a lot of good skills to extract the right information from your client. It's not only like a half an hour session you have a client and you start drafting the matter.
Right.
You need to really have a brainstorming session with your client. And your client really needs to be comfortable with you to share that kind of information that you need to win a case. It is a matter of fact which takes you the order out in the trial court.
So I have a follow-up question there, Sunana. Any memorable or defining case or cases that you've worked and that have stayed with you?
I have appeared for a very well-known artist against a very well-known company in their case of moral rights in Bangalore, copyright matter. I have worked for, again, a celebrity in respect of a defamation matter. And I find these gray areas of law, where there's moral rights or defamation, which is taught, or taught of negligence matters, for example, air crash, wherein you're triggering negligence taught to argue a matter, extremely, extremely good, because that's where my law school training really comes into picture. If it's only arguing a recovery matter or a strictly, IPR matter where trademark versus infringement of trademark is there, you have established judgments and established tools to argue, but there are matters where you don't have tools to argue. You don't have a case law in your favor. You don't have a section in your favor. So what are you going to do next? So you have to assimilate facts. You have to read more on it, what other countries are doing. What is the jurisprudence behind the subject matter? What are the international conventions on it? What are jurists talking about it? Any commission reports on the subject matter across the world? And tell the court about it. See, initially the court may be resisting. But it is your standing on your legs, your common sense, your logical understanding of things, which will make the judge open the book and start reading. So to that extent, I would say that going to all these courts are very, very
Critical.
You cannot say I am
lawyer.
only an IPR lawyer. I am only an insolvency lawyer. Because at the end of the day, all of us want to enhance our legal acumen.
Right.
Like a vocalist is trying to enhance their voice.
So have there been instances, let me ask you this, right? Have there been instances where you have represented a smaller client against a bigger corporate or a bigger client with unlimited resources, and then because of your strategy, you won the case for your client? Have there been such cases? I'm sure
There has been quite a few.
Yeah.
And then, again, I have fought cases against a very well-known production house, movie production house, who also has a lot of business in Karnataka. And I have singularly could stand the good order that we have enjoyed and hold on to the order for quite some time till the matter got referred for arbitration. I think very important to be confident and very important to feel for what your client is asking you to look into. You should not dismiss a client's input as they don't know law. You don't know facts. You have to absorb them. And second thing is fearlessness. Whether you're standing in front of against a chief minister of a country, of a state, or whether you're standing against one of the very, very intriguing businessmen who has large businesses, you must stand on your feet and tell something which you really feel is right, which is really right as per law, than feel like, oh my God, I'm going to lose this case. He's so big. I can't win it. They're going to deploy senior counsels. I will lose. I have argued matters against senior counsels also very systematically, logically. So not to get intimidated because of the whole situation that's created around you. So going back to fearlessness, going back to neutrality, and going back to honesty, and going back to hard work.
Right.
Honesty is also because many a times, people think that lawyers are getting compromised.
Right.
But you are your own talisman. You can look to Gandhiji, you can look to Ambedkar, you can look to Tagore, but you are your own talisman.
So I think self-confidence and fearlessness takes you a long way.
Yes.
Right? Yeah. So Sunana, another question before we move to the next segment. Arbitration and mediation are being promoted as the alternatives for long-drawn court battles, right? So in your experience, how effective have they been? Are they really the alternatives that we're talking about?
I would say that arbitration has picked up, mediation has also picked up, but long way from 20 years back, where we had Section 89, where we had those methods where court can refer to it for a mediation in between a litigation. It does help, and it has helped significantly. You find quite a bit of matters getting mediated and settled, but those matters may be property-related matters, brother-to-brother matters, inter-sibling matters, or husband-wife matters, will matters, uncle and nephew disputes. But matters which involve commercial work, recovery, violation of business transfer agreements, can they really be settled in a mediation? And here, Kirti, I would just want to add one perspective. One reason why it is not getting settled in mediation is because the authorized representative who signs the legal papers are not a part of the decision making of the company.
Correct.
The decision makers are sitting on a board and they may not really micromanage these matters. So you have a pre-institutional mediation process in Commercial Courts Act, which you have to do PIM before you initiate a commercial suit.
Okay.
But you can say that 30% only, less than 30% matters are getting settled in PIM. Why not? Because the people who come in PIM are not really the directors or the person who can take decisions on behalf of the company.
Right.
So there's a big information gap. Other situation where you can mediate definitely very, very effectively is once plaintiff is filed, written statement is filed, issues are drawn up, then people know what are they getting into. And then maybe you can think about mediation. Because pre-institutional mediation, sometimes it doesn't work because clients think that they are going to get X. Or they're going to get X plus 1. But eventually, after 1.5 years of battle, they figure out they will get X minus 20%. So that's when they want to settle. So if you can mobilize the decision makers of a company to step into this stage of issue framing of issues, post which you're going to talk about a settlement, if at all, and that the decision makers of a company can be called upon to just send a letter whether they want to settle or not, with a short paragraph of outlining yes or no, and then they will open the file and say, what is this file about? And should we really pull on with it? It is not really somebody who is just an operation team guy who is signing your legal documents.
No, I think coming from the corporate side of things, right? Since I've been working as an in-house legal counsel, I totally understand what you're saying, right? There'll be somebody authorized on paper, but effectively they will not be making the decisions.
Exactly.
And that's where the delay is. Yeah,
Exactly.
I totally get it. Yeah.
So this is the step I recommend, Kirti, that post-framing of issues, we can actually have a mediation where notice goes to a more senior person in the company who can then make a more choice decision about what they want to do, especially matters involving more than 1 crore. Maybe we can explore this aspect.
Okay. So currently none of these things are in place.
It is all ad hoc.
Right.
It is not systemic.
Right.
It is not mandatory. It is all ad hoc.
Okay. So Sunana, let's, from all this discussion about founding CLC, your life as a practicing lawyer, let's move to your personal life. Let's shift gears to your personal life. So you are a Bengali who loves your fish curry and rice, and you're married to Manu Kulkarni, who is a Kannadiga and is a vegetarian. So that's a very interesting cultural mix at home. What has been that journey like for you?
It has been very good. Yeah.
You just want to end that in a one-line answer? I want details.
No, I think what matters is affection and respect for each other, which we always had. And even if you're eating fish curry in your own kitchen and he's eating sambar tilisaru rice, I think we can coexist. In terms of language, I think English has been a big connector because we all connect in English.
But you have learned Kannada. In fact, I wanted to bring that up, right? I think I'm very proud of you for learning Kannada so well. I know a lot of people who are in Bangalore for more than a decade or so, and they don't still know a word of Kannada, right? So I always show your example, and I'm like, so Sunayana, what prompted you to learn Kannada? And
See,
how
I
has
love
it?
people.
Oh, okay.
Whether I am in Bengal, I love speaking Bengali. And I realized when I came to Bangalore 15 years back, I cannot talk to the grocery store guy. I cannot talk to the people who are walking around me. I cannot talk to anyone. I have to talk to them in Hindi, and which is a language they don't even know.
Exactly.
Forget about English. So then that becomes a mechanism for them to feel uncomfortable. That nange gottilla. So I started going to Kannada Parishad classes, 4 of them.
You did? I did
Yes.
not know about this. Okay.
I went for 4 classes, which taught me the essentials of Kannada.
Okay.
You, me, why, what.
Okay.
The questions that we always ask ourselves. And I started watching a lot of 1970s and 80s Kannada movies for good language. And that's how I picked up Kannada. It connected me to people. It will be a lie that I have picked it up for my family or Manu's family. I have picked it up for the sake of being more closer to people where I am in. Because Bangalore is my home. And wherever I make my home, I have to speak their language. And this has also been my philosophy in court, that if I am going to argue, even if I carry 10 judgments, if I cannot explain to a judge what I am trying to convey, I will never get any order. And the language, Kannada, has become actually a blessing for me because I can communicate things to a judge more easily,
And effectively.
blending it with other language.
Right.
Same for clients. Clients, they may be really good English speakers, but when I tune to Kannada, they are giving me more information.
Right.
And they are so happy to give that information. The connection. Lawyers is all about connecting.
True.
You have to connect to people around you. Then think about people who work in registry. They are sitting in front of a pile of 1,000, 2,000 files all day. Can I go and speak to them in English?
Correct.
They're going to get not comfortable at all. So I think I connected to all the, kind of micromanaged, every player of litigation. You have to be connected, from the clerk to the registry to the people who are going to file, the notary, everyone.
Right.
Notary come to in the night and do notarization. So you have to speak the local language. And in their way, not in your own accent and your anglicized way of speaking Kannada.
Right.
You have to speak Kannada as Kannada is spoken. Like just imagine if you are going to speak Bengali in a different manner. People are going to always think you're not one of them. So I think that has been my driving factors.
That's fantastic, Sunana. One last question before the rapid fire round.
Okay.
I know you've been very passionate about music since NALSAR days. You used to love singing Rabindra Sangeet. You've also been learning Hindustani classical. So how do you so whenever I go to your place, right, either you are singing or Manu is singing. So what is, how do you make time for music? How do you balance it with your work pressures? Because as a litigation lawyer, I recollect even on Saturdays, Sundays, you guys are kind of busy, right? So how do you balance your passion for music as well as your work pressures?
Initially, I couldn't balance the first 7 years of my life as a litigation lawyer.
Yeah.
But I did attempt to balance, maybe once or twice in a month I would go for classes. Now, since I know how the flow of things are going to be in the whole day, I do manage to sing once in a week. And I think singing is extremely good vocal exercise for even litigation.
I never thought about it that way, but yeah, that makes a lot of sense.
And also it feels if you feel very positive.
Right, right.
Again,
yeah.
going back to the board that, if your board is always in darker shades of grey or brown, you have to make it more colorful. And
right.
Music is one of them.
So let's move to the rapid fire round, Sunana.
Yes.
Okay, don't take too much time. Just quick, crisp answers. Litigation or arbitration?
Litigation.
Bangalore or Calcutta?
Bangalore.
Wow, I'm impressed. Okay. Sari or Western?
Sari.
Favorite international lawyer or jurist?
Professor Upendra Baxi.
Okay. Lawyer turned politician you admire most?
Not sure.
Anybody? Think about it. Lawyer turned politician.
Mahatma Gandhi.
Okay. A book that has had a deep impact on you?
A few of them, quite a few of them. Maxim Gorky's Mother.
Okay.
Rabindranath Tagore's Gitanjali.
All right. Favorite city in the world and why? Any places you've traveled to?
I like London
Okay.
because it echoes Calcutta.
Really? Okay.
So it's home away from home. Or you can say nostalgia embodied from where I grew up.
Okay. So Bengali fish curry or biryani?
Bengali fish curry.
What's your go-to comfort food after a long day in court?
Khichdi
Okay.
with tomato chutney.
Oh, you're specific about that. If you weren't a lawyer, who would you be?
Are there options to it?
Politician, judge, professor, musician?
I would say an honest politician.
Is there something called an honest politician?
I'm creating my own segment here.
Okay. Okay. So, Sunayana, this has been a wonderful conversation. Thank you so much for sharing your
Thank you, Kirti.
experience and insights. And I wish you the very best in your future endeavors.